This is what happens when you nominate a judge who can't explain the Sixth Amendment, doesn't know Obergefell, and needs a cheat sheet to define privileges or immunities. It's not just awkward, it's terrifying. This isn't a law school pop quiz. It's a lifetime appointment. If you're not outraged yet, just wait. We break down every stumble, every dodge, and every reason this nominee should not be confirmed.
Mr. Williams, tell me about the privileges or immunities clause.
Thank you for the question, Senator. The privileges and immunities clause.
Privileges or immunities clause.
Right. That's part of the Bill of Rights and part of the, I believe, the First Amendment. It's been a while, Senator. My practice is primarily intellectual property. So it's been a while since I've faced an issue with the privilege and immunity clause. It doesn't come up every day in my practice.
Privileges or immunity.
Privilege or immunity clause doesn't come up every day in my practice. What I can tell you that if I was faced with an issue that involved the privilege or immunities clause, I would review the binding Supreme Court precedent on the issue and apply that binding precedent to the specific facts of the case in front of me.
Okay. Tell me what rights are guaranteed by the Sixth Amendment.
Sixth Amendment guarantees right to a speedy trial.
Right.
Right to counsel.
Right.
And also right to speedy right to counsel, and also that's the fifth right against self-incrimination, which is in the Fifth Amendment.
Okay. Tell me what the holding was in Obergefell.
I'm sorry, I didn't hear the question, Senator.
The holding in Obergefell v. Hodges.
Senator, thank you for the question. I haven't had the occasion to deal with that issue. I don't recall that specific case as I sit here in front of you. But what I can tell you is that if the issue decided in that case came before me, I would review binding Supreme Court precedent and apply it to the specific facts of the case in front of me.
Okay. In 2015, Mr. Williams, you gave a speech, and you said that the modern judicial system today is more racist than it was 100 years ago. Did you say that?
Thank you for the question, Senator.
You're welcome.
I don't believe that's the specific quote that I said. I believe you're referring to...
Let me read you the quote so there won't be any misunderstanding. Becoming a felon is more devastating today than when existed during Jim Crow. And you were talking about the judicial system in Delaware.
Thank you for the question, Senator.
You're welcome.
I made those comments as co-chair of the Access to Justice Commission, which was a commission that was created by the Delaware Supreme Court.
Yes, sir. But
I was asked.
Tell me what you meant.
The chair.
I know.
So,
I read the interview. Tell me what you meant.
I was referring to a description that others have made to describe the condition of felons in terms of the term Jim Crow, meaning...
Well, let me stop you. Do you believe that the judicial system in Delaware, in America, is more racist today than it was 100 years ago?
Thank you for the question, Senator.
You're welcome.
No, I do not believe that the system today is more racist than it was 100 years ago. What I was describing was the...
But why did you say becoming a felon is more devastating today than when it existed during Jim Crow?
I was referring to the conditions of the inordinate amount of people of color who, when they become felons, are faced with loss of economic opportunity, loss of voting rights, loss of driving license, loss
But
of
that happens
housing.
to an Hispanic as well, right?
It happens to
If you're convicted.
It happens to everyone who becomes a felon, but the task of the committee was to examine the reasons why there's such glaring racial disparities in the population of people of color in Delaware as compared to
And
the population
you think that's
of
because of
people
racism?
incarcerated.
You think that's because of racism?
I did not say.
I know. I'm asking you. Do you think that's because of racism
I believe that race plays a factor
in Delaware?
across across the in Delaware and beyond, and that studies have shown that there is a disparity in the prison population that just can't be explained by just nature and it be coincidence, and that race plays some factor. It's not the only factor.
Right.
Economic condition, money, ability to pay bail, etc., plays a factor, and some other things play a factor. So at that time, I was serving as
Right. Well,
chair
let me
of
stop
that
you because my chairman here has been very, very indulgent. I'm going to ask you one last question. Do you think photo IDs, requiring a photo ID to vote, is inappropriate?
Thank you for the question, Senator.
Welcome.
The Supreme Court has held that voter IDs
Right.
Requirement for voting
What do you think?
is permissible.
What do you think?
I, Senator, follow binding Supreme Court precedent.
Yeah, but what do you think? You've written articles saying that's racist, haven't you?
I have not.
Okay.
I have not.
Well, you've written articles opposing voter ID, have you not?
I have not.
Okay. So you think it's okay?
I do.
Okay. That's all I got. Thanks, Mr. Chairman. Thanks for your indulgence. Judge, congratulations. I'm not going to ask you your opinion on precedent, and I'm not going to really ask you about past cases. I just want to talk to you a little bit. Judge Lee, tell me what your understanding is currently of the Chevron doctrine.
Thank you, Senator Kennedy, for that question. My understanding currently of the Chevron doctrine is that the doctrine is a general matter that courts should give deference to agency factual determinations to the extent that the agency has been empowered by Congress to regulate certain areas.
How much deference have the appellate court said you should give? Explain what you mean by giving them. I know what deference is, but do you give them a lot of deference? What if they come up with an interpretation that is patently absurd? Do you have to defer to that?
Thank you, Senator Kennedy. Senator Kennedy, I know that the issue of the Chevron doctrine and the deference that courts should afford to agencies is an issue that is currently hotly contested in various litigation. And as a sitting district judge and as a nominee for the Seventh Circuit, I feel that it would be imprudent to provide my advisory views with regard to that issue.
Look, I agree with you, Judge. I'm not asking your advisory view. I'm asking you to tell me what the law is. What's the current state of the law? I agree with you. Under Chevron, the courts have said Congress has delegated this expertise to the regulatory agencies. You're supposed to defer to them. What is the current state about how much deference and when, if ever, you don't defer to them? That's all I'm asking.
Again, Senator Kennedy, given how hotly contested that issue is, I feel that at this point in time, as a sitting district judge and as a nominee to the Seventh Circuit, that
Judge, let me interrupt you. You're
yes.
telling me you can't tell me what the state of You won't tell me what the state of the law is on the Chevron doctrine? I'm not asking your opinion on it. I'm just telling me what's the latest guide. Let me rephrase it. What is the latest guidance that the United States Supreme Court has given us on the Chevron doctrine? I mean, it's pretty important stuff.
Yes, Senator. The Chevron doctrine, as I stated, was that the court should give deference to agency determinations in matters that specifically deal with their particular realm that
Right.
Congress has
We
delegated.
went over that. How much deference? When do you not defer to the agencies?
As I recall, Senator, the degree of deference that a court should afford agencies really deals with the process that the agency went through in making its determination, as well as to the exact and precise nature of that determination.
Yeah, I don't agree with that, Judge, but that's okay. I'm surprised you haven't seen the issue of Chevron before. You're going to see it on the Court of Appeals. It's pretty important stuff. Let me ask you, Judge Mendoza, one question. I've only got a little bit of time left. Look, you wrote a law review article back in law school, and I don't hold that against you. You know, when I was in law school, we all did things when we were young that, you know, it seemed like a good idea at the time, okay? But you made, if I got this wrong, tell me. But you made one statement. I was looking at your piece. I think this came from your article. I'm gonna read you the quote, and I just didn't understand it. Here's your quote. One must understand race as a socially constructed phenomenon that has historically served to subordinate racial minority groups while maintaining white supremacy. I've never thought of race as a socially constructed phenomenon. Tell me what you meant by that statement.
Thank you, Senator, for that question. And I think you're referring to that article that I wrote 26 years ago,
Yeah.
when I was a law student. And of course, since that time, Senator, I've became an attorney. I swore an oath. At that point, I became a judge.
No, I'm not trying to trip you up. I'm just trying to understand what you meant by it. When I first read it, I said, well, you know, that's an interesting construct. I just don't understand it.
And Senator, as I sit here now, I can't recall that specific quote, but what I can tell you is when I deal with the issue of race in my court, it's usually in a claim. And what I do in those claims is I apply the precedent on the matter. I look at the facts and I make those determinations and base my decision only on those issues and nothing else.
Okay.
Let's be honest, watching Mr. Williams stammer through basic constitutional questions wasn't just uncomfortable. It was unforgivable for someone seeking a federal judgeship. If you're asking the Senate for a lifetime seat interpreting the Constitution, maybe, just maybe, you should be able to identify which amendment the Privileges or Immunities Clause belongs to. Spoiler, it's not the first. When Senator Kennedy asked about that clause, what followed was a full-blown constitutional meltdown. Williams flailed like a deer in headlights, mixing up the First Amendment, the Bill of Rights, and his own career experience. He tried to deflect by saying he focuses on intellectual property. But here's the thing. Federal judges rule on everything. This isn't traffic court. You're applying to be a guardian of the Constitution, and you're struggling to name what's in it, and it only got worse. When asked about the Sixth Amendment, Williams could barely piece together the right to counsel and the right to a speedy trial, but then tripped and tossed in protections against self-incrimination. That's the Fifth Amendment, for those keeping score at home. Then came Obergefell versus Hodges, a landmark case in modern civil rights. Williams had no recollection, not even a vague understanding. He couldn't cite the holding, the subject matter, or even the decade. He says he'd apply the precedent. But how can you apply something you can't even name? Let's be blunt. This wasn't just a lack of prep. It was a complete exposure of someone utterly unqualified for the bench. If he's this lost in a confirmation hearing, how's he going to handle real cases with real people's rights on the line? And then the hearing pivoted into something darker. Williams was confronted with his past comments, specifically his speech claiming that becoming a felon today is more devastating than living under Jim Crow laws. You read that right. More devastating than a system of legally sanctioned apartheid. When pressed, Williams tried to spin it into a conversation about economic consequences, but the damage was done. That comparison wasn't just inaccurate, it was historically tone-deaf and deeply offensive. We're talking about someone who claimed, in public remarks, that America's modern legal system is more racist than it was a century ago. And this isn't some forgotten college essay. These are statements made as a co-chair of a state commission. This is who the White House wants to elevate to a lifetime federal appointment, but the train wreck didn't stop there. Williams was asked about voter ID laws, another fundamental constitutional and political issue. His answer? I think it's permissible. That's it. After a career in law, he has no opinion. He's never written about it. He claims he's never opposed voter ID in any public forum, despite serving on justice commissions and issuing racial disparity reports. And then came Judge Lee, the next nominee, asked to define the Chevron doctrine, a cornerstone of administrative law. Her answers were textbook evasion. She knew the issue was controversial, so she stonewalled, refusing to even state the current Supreme Court precedent. That's not caution, it's cowardice. Finally, we landed on Judge Mendoza, who was confronted about a law school paper where he described race as a socially constructed phenomenon designed to maintain white supremacy. That might sound like abstract theory, but this isn't a college classroom. It's a confirmation hearing. And Mendoza's explanation? He couldn't remember writing it. He distanced himself from it, but not by offering any personal belief. Just more hedging, more dodging. Bottom line, this wasn't a vetting. It was a showcase of intellectual fog, ideological radicalism, and dangerous unpreparedness. These aren't judges who will stand on principle. They're rubber stamps with law degrees. And if you think that's harsh, imagine being a defendant in their courtroom, hoping they at least remember which amendment grants you a right to a lawyer. This isn't about party, it's about standards, and every single nominee here failed the test. Thanks for sticking with us through this jaw-dropping hearing. If you're just as stunned as we are, watching judicial nominees fumble basic constitutional questions, dodge race-related accountability, and cite, "It's been a while," like that's a valid excuse, then this system needs eyes on it. Yours. Smash that like button if you believe the American people deserve better. Drop a comment below. Did anything you heard today give you confidence in our courts? Share this video to help expose what's really happening inside these confirmation rooms. And don't forget to subscribe to Malcolm Veyron Talks so you never miss the next explosive breakdown. I'm Veyron. Thanks for watching. Stay sharp, stay loud, and stay watching. We'll see you in the next one.